All right, microphone check, microphone check. Can you guys hear me? Let me check the outside. All right, microphone. All right, so now this is good. You guys can now hear me. Sorry about earlier. I don't know what's going on. I think we have some background noise. All right, so welcome to this edition of Skills. We are going over the 2017 final. I'm going to also give you guys some tips and tricks for just the evidence exam. So what I'm going to do is I'm going to go over the multiple choice first, the 15 questions multiple choice. And then after we go over the multiple choice, we're then going to go look at the essays and the best ways to tackle some of the essays. And I'm also going to give you guys some advice on how to analyze both the essays and some of the multiple choice, things that I use that I think were successful. So before I start, let me make sure I'm going to screen share my screen so you guys can see what's going on. My screen isn't sharing. Why are you acting up, computer? Oh, screen isn't going to share. All right, I'm going to have to do something else. Let's try this one more time. Let's screen share. Here we go. Okay, I hope everybody can see my screen. These are the 15 multiple choice questions. So let's start with the process of how I usually go through a multiple choice question. I'm going to be monitoring both the side chat and the chat for the YouTube link. So just let me know if you have any questions. You can type the questions into the YouTube chat, and I'll be answering them. Or if you're in the room, you can just speak and I'll answer your questions. Okay, so we're good now. So here we go. I'm going to present to everyone. All right, so let's just jump into the first question. All right, so the way I generally jump into these questions, the answers are going to be here, but I'll move it down. So the way we generally I'm going to jump into these questions. I like to read the call of the question first. Now, we've all taken the LSAT. If you're in this evidence course, more than likely you've taken the LSAT. And if you have taken the LSAT, remember when on the LSAT they always said you should always read the call of the question first. And why is that? That's so you can have an understanding of what you're looking for. Now, particularly when we're talking about evidence and Professor Valentine, there's a lot that she triggers in her questions. She likes to give you questions that make you think about a whole host of topics while you're reading through the question. So why I suggest you read through the call of the question, because it narrows your focus to exactly what she's looking for, and it'll be less harder for her to trick you with things that trigger other doctrine. So that's the way I'm going to be going through this. But now I do want to say this with a caveat. If you typically get all of her questions right, reading them straight up and down or whatever tactic that you use, I would say continue to use that. But if you get confused with some of her questions, then I would suggest doing this, because this does help. But again, it's really about a personal preference, what works best for you. So let me start with question 1. All right. So question 1. Again, I'm going to start with the call of the question. If the prosecutor objects to the question, the court will most likely. Okay, so I see here prosecutor objects to the question. So I know I'm in a criminal trial. This call to question doesn't really give me a lot, so I'm just going to go right into the question to see what we're looking at. A defendant money manager is charged with embezzling from Steele Co. Financial, where he currently works. At the trial, the defendant calls a witness. Okay, so criminal trial, and the defendant calls a witness, his former supervisor at XYZ Company, where he just prior to taking the job at Steele Co. That's where he worked prior to taking the job at Steele Co. The former supervisor testifies that he worked with the defendant for over 8 years, okay, at XYZ Company, and the defendant had a very good reputation for honesty here. So it seems like if we stop here, this is a character witness who's just testifying that he knew the defendant for over 8 years. That's how he knows what he knows, and that the defendant has a very good reputation of honesty, reputation and opinion. Next, the defendant's attorney seeks to elicit testimony that the defendant had often been entrusted with large sums of cash without incident while employed at XYZ. So it seems like the defendant's attorney wants to ask our character witness about a specific instance of conduct. The fact that this person was entrusted with large sums of money without incident. So we have here a character witness who has testified to reputation and opinion, and now the defense attorney is seeking to find out whether this character witness can testify to specific instances of conduct. So we should know directly from the rules now that you cannot elicit specific instances of conduct on direct examination. This is generally held for cross when and you're stuck with the answer when you do ask the witness about a specific instance of conduct. The witness is testifying to reputation and opinion. So let's look at the answer. So we're looking for two things. We're going into our answer choices. We're looking for one, we're looking for this not to be admissible because this is asking a character witness about a specific instance of conduct on direct. So A, sustain the objection because the testimony would be extrinsic testimony on a collateral matter. That is not what we predicted. This is a character witness talking about reputation and opinion, and now wants to, the defense attorney wants to bring in evidence of a specific instance of conduct. B, sustain the objection because the defendant is limited to proving character by reputation or opinion testimony only. That's what we predicted, and that seems to be the correct answer. Let's look at C. Overrule the objection because the testimony is evidence of the defendant's pertinent character trait as allowed under the mercy rule. But again, we're talking we're not talking about let me see. Overrule the objection because the testimony is evidence of the defendant's pertinent character trait, which is allowed under the mercy rule. No, because again, you cannot elicit testimony of a person's pertinent character trait to show that a person I don't know, now I'm fumbling my words. You can't show character to prove that a person acted in conformity with a particular character trait. And that's what C seems to be saying. And we're assuming that they're going to sustain this objection, not overrule it. So again, they're going to, for D, it says overrule objection. We're going to sustain this objection, but it's overrule objection because the testimony is relevant to the crime being charged and not unduly prejudicial to the prosecution's case. But again, this is character evidence. And on top of that, this is character evidence asking about specific instance of conduct on direct examination, which is not allowed under Rule 404 and 405 for methods of proving character. Sorry, I fumbled through that one, but all this technical difficulty. So the correct answer for one is A, because this is character evidence being offered for reputation and opinion, and they're asking about a specific instance of conduct, which is not allowed unless you're on cross-examination. Moving to question 2. Again, I'm going to start with the call of the question because, again, I like to see what I'm looking for when I go into the major questions. So let's look at the end. Yvette's attorney objects, stating that the evidence is not relevant. The court will most likely. So this seems to just be asking us about relevancy. So hopefully this question will be nice and easy since it's just about relevancy. Let's now go in, understanding that we're talking about evidence being relevant. Yvette was driving south on Main Street. She was approaching the light at 24th and Main. Wanda, who was then the car next to Yvette, observed Yvette texting on her cell phone. 3 minutes later, at 16th and Main, Yvette turned right on green, accidentally striking Paul the pedestrian. Paul brings a personal injury suit against Yvette, claiming she was operating her vehicle in a negligent manner. At trial, Paul's attorney wants Wanda to testify as to what she saw Yvette doing on 24th and Main. So he sees Yvette on 24th and Main texting, and then 3 minutes later at 16th and Main, about 8 blocks later, she accidentally hits Paul the pedestrian. So does her testimony, is it relevant to this injury case, to this personal injury suit? Does it make a fact of consequence more or less probable? I would say it does if she's texting 8 blocks away, and and if somebody sees her texting 3 minutes earlier and she's in an accident 3 minutes later, it does make it more probable than not that she was being negligent when she caused this accident. So that's the answer we're looking for. And it seems here that C is the one, because we're not going to sustain this objection. We're going to overrule it. And C says overrule the objection because Yvette's actions while driving on 24th and Main provide some proof, however slight, that Yvette was not paying close attention while driving. So C seems to be the best choice. This was a pretty easy question, so I'm not really going to go into all of the answers, but I think this is pretty clear. Does anyone have any questions? All right, I'm going to be moving on to question number 3. So question number 3, defendant, here, let's go. The prosecutor seeks to have the witness's testimony at the grand jury admitted into evidence, and the defendant objects. What should the court do? So this tells us a couple of things again. This tells us we're at a criminal case because we have a prosecutor. And we're talking about witness testimony at a grand jury. So we're talking about this is at a prior proceeding, a witness testimony at a prior proceeding. And they're trying to offer this against the defendant. And the defendant is objecting to this. So we're really thinking about, before we go into the question, we're talking about hearsay, we're talking about an exemption hearsay, it looks like. Just by the call of the question. That's what I'm getting. So let's read it. Defendant is charged with assault and battery when he allegedly attacked the victim who had knocked him off his bike. Witness testified at the grand jury that he had seen the victim carelessly open the car door into the bike lane, causing the defendant, who was riding his bike, to swerve and fall. The witness further testified that the defendant jumped up and grabbed the victim out of the car and began hitting him. However, at trial, the witness changed his story. Witness changed his story at trial. On the stand, the witness testified that after the accident, the defendant jumped up and began yelling at the driver of the car. That it was the driver of the car who threw the first punch, and then both men started hitting each other. So the prosecutor seeks to have the witness's prior testimony, which is different than this testimony, admitted into evidence. So can we get it admitted? Can we not? So let's look at A. So A says, admit the prior testimony for the truth of the matter asserted under former testimony. And B seems pretty similar too. Admit the prior testimony for the truth of the matter asserted under the declarant witness prior inconsistent statement exemption. So this is testing our knowledge of between the two rules. Former testimony exception and but the declarant witness prior inconsistent statement. So what's the difference between these two answers? Because it's true, if we get through one of these exceptions or exemptions, we can let it in for the truth of the matter asserted, but there's a pretty big difference between these two. Now, I would throw it out to people who are watching, but I don't know, does anybody want to tackle what the difference is? What the main difference is that we're looking for? Gail, you want to take a shot at it? Uh-oh, I think everybody's still muted. All right, well, it seems like, what are the requirements for former testimony? Here, we have the witness is available and actually is on the stand and being cross-examined. And generally, with former testimony, this is dealing with the witness who's unavailable. So we have an available witness. It's different. Let's actually
Does the prior testimony have to, the defendant's attorney have to be able to cross-examine the witness?
Hold on, I'm sorry. Can you say that one more time?
For the former testimony exception, does the defendant's attorney have to be able to cross-examine?
Let's go. Let me pull up the rule. Let's look at the rule. Give me 1 second. Let me pull up the rule so we can look at the rule together. Where is this rule? For E. All right, for former testimony, sorry, let me screen share this screen too. All right, for former testimony, there's a requirement, and the requirement is for the declarant to be unavailable. So in our fact pattern here, the declarant is available. The declarant actually has testified both in the is testifying at this trial, right? The witness testified that the defendant, so this witness is not unavailable. For former testimony, the witness, it's under 804, the witness has to be unavailable. So here the witness is available. So that's why A isn't the wrong answer. You guys get that? So here for B, you have a witness for B for a prior inconsistent statement exemption for the hearsay rule. The witness has to be present and available for cross-examination, which you have here. And don't forget, there's also the requirement that the former testimony, prior testimony, had to be given within in a certain legal matter. What is it? Under oath, and I forget now my mind is going blank. But being testifying at the grand jury does fall within the exception. So this is clearly a prior inconsistent statement under the exception under 801. Not former testimony, because this witness is available. So that's why in this particular case, B is the answer. You would admit this under prior inconsistent statement exemption and not former testimony exception. I hope you guys got that. I'm going to move to question number 4. Question 4. Again, stating with the call of the question. If Susan is called to testify, she. Okay. So now that gives us nothing. So I'm just going to go right into the question again. Tammy and Susie are planning on getting married. Yay. And Susan, I should say. A month before the marriage, Tammy tells Susan that she put herself through graduate school selling dope, but that she stopped right after graduation. Okay, so we're planning to get married. This is now triggering all in my mind marital exception and spousal privilege and marital privilege. This is triggering. This is something that happened before the marriage, so we're not talking about marital privilege. We're talking about spousal privilege. It's things that happened before the marriage. Susan was not in trouble by the information and told Tammy, "Don't worry about this, but let's put it behind us and never talk about it again." Tammy agreed, and the couple married and planned and never spoke about Tammy's prior drug dealing again. So as long as they stay married, then we have the spousal privilege applies. And again, remember, that's the one that only the spouse that's testifying has that privilege. It's not the spouse that on trial. It's specifically for criminal trials too. So several months after they were married, Tammy was arrested, oh my God, for drug possession with intent to distribute. The prosecutor subpoenaed Susan, demanding that she testify to the grand jury as to what Tammy told her about Tammy's prior drug dealings. So if Susan is called to testify, then obviously Susan could refuse to testify claiming spousal privilege because this is a criminal trial. So that's what we're looking for. since this communication didn't happen during the marriage, the defendant, Tammy here, doesn't have the ability to call this privilege. It's only going to be Susan because we're talking about spousal privilege and not marital communications. So let's see the call of the question. Let's see the question, the answers. A must answer the question. There is no privilege that protects this information. That's obviously wrong. Cannot answer the question because marital communication privilege protects this information, but this is not marital communications privilege, it's a spousal privilege. So the person on the stand could answer because they're the ones that hold the privilege. Cannot answer the question because the spousal testimonial privilege protects the information. It does, but she can still answer. Remember, she can waive the privilege on the stand. May answer the question if she wants, but does not have to answer because spousal testimonial privilege protects the information. And D is the answer. If there's any questions about question 4. Moving on to question 5. But as you could see, I marked out question 5 because question 5 is about public records, and public records are not going to be on this final exam. So if you didn't know, now you know. Question 5 is gone. Question 6. Now, question 6, if you just read, let's start with the call to questions. The defendant objects to the testimony as hearsay. The court will most likely. Okay, the court will likely. So we're talking about a hearsay. We're talking about an objection. So hearsay is an out-of-court statement or for the truth of the matter asserted, unless we can get it under one of those exemptions or exceptions. So we're looking to see if this is hearsay, and if it is being offered the truth of the matter asserted, then it should be out unless it falls within the exception. Question 6 starts, inheritance of the estate depends on whether the wife survived her husband when both died in an auto accident. Family members bring suit to settle the estate. The plaintiff is the daughter of the wife from a prior marriage and is claiming her mother, the wife, outlived her husband, if only by a few minutes. Plaintiff calls a witness who will testify that when she approached the car crash, she heard what she thought was a woman's voice saying, "Help me, I'm dying. Please help me." However, by the time the couple was pulled from the wreck, both were pronounced dead at the scene. So we have an out-of-court statement being offered for what? It's being offered to prove that this woman was alive. The statement is, "Help me, I'm dying, please help." So, is this hearsay? Is this hearsay? Is this statement being offered to prove the truth of the statement that she was dying, or is this statement being offered to prove that she was still alive? So, looking at the statement and understanding what we're offering it for, we're not offering a statement for the truth that she was actually dying, that she's actually dying. We were offering this statement to show that she was still alive. So this statement doesn't seem to be as this statement is not being offered, it seems to me, for the truth of the matter asserted, because we're offering this statement to prove this person was alive, not the fact that this person was dying, which is pretty, which is really dicey, which are really splitting hairs here, but that's kind of what's happening. Because again, we need to know who died first and last, and if this statement was said, this statement, and think about it this way, this statement could be anything. This doesn't have to say, "Help me, I'm dying." You can say, "Can you bring me a Coke?" or "Can you bring me some soda?" or, "Hey, how was my dog?" Any statement that would have been made would have also been admissible because we're not proving that statement is true. We actually just need to make that a statement was said to show that this person was alive. So let's look at the answer choices, and here the correct answer choice is A, the evidence, omit the evidence because it is relevant and not prohibited. It is not hearsay. And think about it this way. If this statement wasn't just "Help me, I'm dying," it could have been anything. It could be, bring me a glass of water. But it's the fact that the statement was made to show that this person was alive. That's why this is the best answer. Any questions? All right, moving on to question 7. Okay, question 7, it starts off with, if the defense objects to the introduction of photographs as hearsay, the court will most likely. Well, this actually tells us a lot already, because generally photos aren't hearsay because they're not statements. They're just mechanical representations of events. So since they're not statements, they're generally not hearsay. Now, also, we have to understand if something is written on a photograph, like a marker or something, those would be statements offered to communicate some facts, but the photos themselves are not. So even without reading the rest of the question, I would understand that the photos themselves wouldn't be hearsay, but if anything were written on the photos, it probably would be. So here, to be honest with you, I would actually look at the answer choices first, just to see if I have anything like that, where, anything that says exclude the photos. I'm like A and B both say exclude the photos, but C and D say admit the photos as labeled because they are not assertions, and this D says admit the photos but only if there is additional corroborating evidence of the location of the defendant's arrest. So here, I tentatively, it looks like the best answer may be C, right? But I'm not sure. Let's read the rest of the question. The defendant is arrested for hunting in Big Forest Wilderness Preserve in Montana, where hunting is not allowed. To preserve the surrounding, the preserve is surrounded by thousands of acres of wilderness in which hunting is allowed. Generally, because of the difficulty in determining exactly where one is, the vast wilderness area, hunters who stray into the preserve are merely given a warning to leave the area. However, the defendant has been found within the preserve boundaries multiple times, and when the federal game warden finds him more than 2 miles. No, let me reread this. However, the defendant has been found within the preserve boundaries multiple times, and when the federal game warden finds him more than 2 miles within the preserve borders with a dead mountain goat, they arrest him. At trial, the prosecution seeks to admit several wide-angle lens photographs of the defendant campsite of the defendant's campsite, showing it as at the base of Crooked Nose Peak, a well-known mountain within the preserve-bound borders. The prosecution has placed several markers on that photographs labeling various landmarks and trails, as well as a location within the defendant's camp located with. I don't know why I'm chopping. This question is just giving me such a hard time. I don't know why I'm chopping it up. But simply put, we have pictures. There's some markings on it telling us where things are at within the pictures. So I'm looking to say omit the pictures because they're not assertions, but any labels, but the labels may be. So let's see what the answer is. The answer is B. And exclude the labels placed on the photographs. Oh, I did see. This is good while I'm doing it like this. I missed it. Exclude the labels placed on the photographs, what I said before, and omit the photographs. And the correct answer is B, from U.S. v. Lazarga. And it says photographs make no assertions. They are mechanical reproductions, just like we suggested. But however, labels placed on photographs by humans are assertions and are made to communicate facts. So B makes that, excludes the labels, but admits the photographs. Labels are the assertions, the photographs are not. So B is the correct answer choice. Why did I read C so badly? Maybe this is just a bad question for me. I think I just read it so poorly. But B is the correct answer choice. I hope you guys got that. Did I chop that up so bad? Should I do that question again? I feel like I chopped that question up horribly bad.
Hey, can you hear me?
Yes, I can hear you.
Just a quick question before we leave that question.
Okay.
So if those assertions, the labels on the photographs, which are the assertions, right? if they were independently verified, would that change the equation? And I'm asking because D, I got B when I did this, but D kind of suggests something to that effect.
All right. Well, you can actually think of both of them as two separate entities. The photographs is one thing, and the labels is something else. So
Right.
if you're doing the analysis, that's how you should do the analysis. Say photographs are not hearsay, not assertions, but each label is an assertion. So that's how you should analyze this question. The labels separately from the photograph. But generally, what she's trying to do is have you say the photographs and the labels are one thing, and then make the analysis of them together. But they're not. They're two separate things. Does that help?
So let's say that the call of the question said that after the individual labeled the photographs, those
Okay.
labels were verified by the National Geological Society or something like that, right? Where the statements that were made in the form of labels on the photographs were verified by some third party as being accurate. Would
Okay.
that change the situation?
No, because those labels would still be out of court statements over for the truth of the matter asserted.
Okay.
And the
All right,
statement,
thanks.
the statement being they're trying to communicate a fact. So even if they were verified, they would still be hearsay. All right, I'm going to actually try to read this one slower because I fumbled through that last one so poorly. Question 8. Bailey is a witness. I'm sorry. You see, I'm Joan. I'm just reading from the top, going right to the bottom. If the defense counsel objects to the question about Bailey's prior identification, the court will more likely. So with this, sorry. Sorry, I muted myself. Okay, so for this question, if the defense counsel objects to the question about Bailey's prior identification, the court will most likely. This actually gives us a lot. This is number one, defense counsel objects to Bailey's prior identification in court. So we understand this is going to be one of those hearsay exceptions about prior identification and understanding how that works. So we have a prior identification and defense counsel is objecting. So let's read through the question now, because it seems like generally this is going to be let in because this seems to fall within the hearsay exception, prior identifications. But let's look. And obviously you have to be available for cross-examination present at the trial. So let's look. Bailey, it went into the criminal case. Defendant was charged with robbing a local store. Bailey saw the robber as he ran out the store with the owner of the store running after him, yelling, "That guy just robbed me." Bailey gave a statement to the police the day of the robbery and a week later. So the day of the robbery, this is the guy a week later. Identified the defendant in a police lineup. At trial, Bailey took the stand and testified. At the end of direct examination, the prosecutor asked Bailey to point out to the person he saw run from the store the day of the robbery. Bailey pointed out the defendant. The prosecutor then asked Bailey, "Is it the same person you identified a week after the robbery?" Defense counsel objects. So this seems to fit firmly within the exemption to hearsay of prior identifications. Witnesses on the stand, available for cross-examination, made a prior identification, and it seems like we're checking all the boxes for that exception. Here, C is the answer. We're going to overrule the objection and allow Bailey to answer. And the professor writes, prior identifications can be exempted as long as the declarant witness is available for cross-examination, which is here. The defendant, the declarant witness is on the stand, available for cross-examination. Moving to question 9. Now again, just want to make sure, does anyone have any questions about what we've already gone over? All right, moving on to question 9. All right, question 9. The plaintiff was in, There we go again, going right to the call of the question, the full question again, without looking at the call. So let me go back to the call of the question. If Walmart objects to the testimony, the plaintiff's best argument to admit the statement is, but I'm going to say we're going to skip question 9 because question 9, I remember the Walmart question, that is about offer to pay medical expenses, which was not on our exam, so I'm not going to waste your time with going through those. Let's move to question 10. Question 10. Plaintiff's counsel moves for a new trial and then seeks to call the juror and bailiff to testify to support the motion. The court will most likely. Well, again, this is something that for last year we did, but for this year we didn't do it. We didn't do it. So I'm going to move past this question too. So 9 and 10, we're not going to go over because it's just something that's not going to be on our exam, and I don't think it's even worth us going over. Let's go over 11. So here, Sid is charged with attempted murder because someone fired at the police when the brothers were running away. Sid's attorney seeks to have Billy testify as to Tom's statement. If the prosecution objects to the testimony as hearsay, the court will most likely. So we got attempted murder and we have Billy's testimony. So, and the prosecution is objecting to hearsay. So we have a criminal trial. So let's see what's happening. Tom McGuire and his brother Sid tried to rob the local 7-Eleven. Robbery was disrupted when a police car pulls up in front of the store. Brothers bolted out the back door, and one of them shoots at the police officers giving chase. Tom was hit by a car as he ran across the highway trying to get away from the police. He was very badly injured and did not expect to live very long. So this is all reading like dying declaration. He's hit, he's dying. His sister Billy comes to see him at the hospital. So we're at the hospital. Tom gathers his strength and said, okay, looks like here comes a dying declaration. I know I'm not going to make it. Sounds good, right? He's under the impression that he's going to die. So we have the first one of the triggers for a dying declaration fulfilled. I think I'm going to die. Tell the judge, okay, I shot the cop, not Sid. Sid did not even know I had a gun. In fact, he made me promise not to bring one. Tom then lapsed into unconsciousness, and a few hours later he died. So we actually died. So we have one available witness, dying declaration. All right, this is interesting. So it's interesting, but it seems to be a very self-serving dying declaration. Doesn't seem to be. It seems to be one where he's trying to protect someone, it seems not to fulfill the requirement for dying declaration. So let's look at dying declaration to see if this actually fulfills the requirement for dying declaration. Where's my other? I don't have my the file. I don't know what happened. It just closed on me. All right. Well, I can't show you that slide. So let's just look at the professor's answer choice here to save us some time. So she's saying the correct answer is to exclude this testimony as inadmissible hearsay. Why? Because it's a dying declaration. Dying declarations are only admitted in homicide cases. This is a dying declaration, but this is not a homicide case, and civil cases. So this is actually pretty tricky because it's a robbery case. So this is the reason why this would not be allowed, admissible as hearsay. This would be inadmissible hearsay because it's not a dying declaration, because it's not a homicide case, and it's not a civil case. Anybody have any questions on that? And it wouldn't be statements against interest because it seems more self-serving than anything else. This is a grand jury adjudication requirement. Oops. Okay, so let me go back to number 6. I have a question about number 6. Let me go back to number 6. Number 6. All right. Gail, you can unmute and just tell me what's your question for about number 6.
Okay. Hi, can you hear me?
Yes, I can hear you.
So it's more in general that I'm having difficulty determining whether the evidence is being offered for the truth of the matter asserted or for something else. So I did not get the right answer. I got the right answer, but I really didn't understand why, because I can't distinguish those two.
No, what do you mean? You can't distinguish what? Say that one more time.
Whether the evidence is being offered for the truth of the matter asserted or for something else. So for me, forget it. It's okay. I think I figured it out.
No, a lot of people have this problem, but just bear with me 1 second. I want you. Let's do a couple. Let's do 2 things. For this question, let's change this. You see this, I'm dying, please help me. I'm going to change that statement to, do you see how I changed the statement? Gail?
Yes.
All right. So now let's go through this question again, but this is a statement that we want. So the problem with the suit that we have is dependent upon who died first, right? Either the wife or the husband, correct?
Right, but the thing is, and I think I might just be overthinking it,
Right.
is that she heard the wife say something, but that doesn't imply that the husband was dead. It just implies that she didn't hear him say anything.
Exactly. So this evidence of a woman's voice saying, "I want an A on the final." What are we bringing that in for?
To show she was alive.
Correct. Now, even though you're thinking about the husband being dead, that is of no consequence. This statement we want to bring in to show the husband was alive. Not the husband, the wife was alive. So this statement, "I want an A on the final," it doesn't, that can be true or that can be false. We don't care about whether that statement is true. It's the fact that she just said the statement is why we're trying to bring it in.
Okay.
Does that make sense?
I mean, yeah, I guess when I think about it, the evidence isn't worth very much because it only shows that she could say something at that time. But I guess that's going 2 steps too far.
Yeah, even though you're right, it probably wouldn't be worth pretty much, but it's valuable because if she said anything, she was alive.
Right. So it's that low bar of relevancy. That's why it comes in.
Exactly. Well, yes, it's extremely low. The fact that she said something means that she was alive. Now, does that mean the husband was dead? No, but it means it just makes it more probable than not that she survived him. There's a huge case in torts, if you guys take Rules and Trust, where there was an actual plane crash, and there was a husband and wife, and they had wills where the husband's family would get everything if he died last versus the wife's will. And the cop, he goes to the scene and he testifies the husband said, "I'm still alive." And it was like a big issue with that statement because, the statement was, it was like, it was hearsay because we were showing it to prove the truth of the matter that he was actually alive. But then it was kind of like, well, we're not offering to prove he was alive. We're just offering to prove that he said something. So that was actually, I think, where she got this example from, because there's an actual famous case in Wills and Trust about the same issue. Let me move on to Raman. He said, "Nate, for our purposes, grand jury testimony meets the adjudication procedure requirements for 804B1. I believe so, yes. But I'll double check with that just to make sure. Let me go back to this. And we left on question 11, going to question 12. I don't know, something is wrong with my computer because it's funny because I had it all set up where I had the federal rules and everything set up on one side so we can go back and forth, but it's like it's not popping up for me. Nah, I gotta call IT. These Macs are now it comes up. These Macs are gonna kill me. Here we go. I have to do this. All right, much better. All right. So I've gotten my groove back now. Okay, so let's go for 12. All right, 12 is the call of the question here is, what is the plaintiff's best argument as to why the report is not protected by a privilege? So we're talking about privileges and whether this report is protected by a privilege. So Windsor Bus Tours, WBT, has a long-standing internal policy of appointing an outside investigator to review any and all accidents that are affecting passengers on the bus, on its bus tours. Okay, long-standing policy. The investigator creates a report that is reviewed by high-level management to see if safety standards have been compromised or need to be updated. So this seems like this is a pretty tight business record. This is something they do all the time, and it seems like the question said, you know, it's a long-standing internal policy that they always do this in all these situations. Plaintiff was injured in a bus accident involving WPT bus on which she was a passenger. As per the policy, an investigation was initiated the day after the bus accident. A report was provided to WBT 3 weeks later. So again, this is checking all those boxes. This is something they do all the time. It's an automatically generated report. That's, you know, it's something that is done in the course of business. 8 months after the accident, plaintiff sues for damages. During discovery, plaintiff's lawyer demands a copy of the investigation report on this particular accident. This is a business record. You do this all the time. I want to see it. And the attorney for WBT declares the report to be privileged. Okay, so they're saying it's privileged. What is the plaintiff's best argument on why the report is not protected by privilege? So let's go through the answer choices. Well, the report was not prepared for litigation, but as a matter of company policy. That's exactly what we've been predicting. They give us all these trigger words, appointing it for any and all accidents affecting passengers on the bus. They do this, you know, this is just a regular business record in the course of their doing business. So A seems like the perfect answer. The company's general counsel did not request the report. That has nothing to do with it. The investigator was not an employee of WBT. Again, this is about the report being generated because of as in the course of business, and the report is relevant, and the plaintiff would face difficulty in gathering the information elsewhere. Again, this seems to be A pretty clearly. I don't know. I hate to overthink it, but you know, this was not prepared for litigation, but as a matter of company policy. So it seems like that A is the best answer. Anybody have any questions on this one? I'm looking at both the chat, inside and out. Nobody has any questions. I'm going to move over to number 13. Bob and Carol are married. Oh, sorry. If the prosecutor subpoenas Carol to testify as to what Bob told her the day he left Carol. So we got a prosecutor subpoenaing Carol to testify against Bob. All right, so we need more. We can't really kind of do anything just with that call to question. Let's go into the question to see. Bob and Carol are married, though they had grown apart. So married, okay, so married. So we have two privileges we're thinking about. We're talking about the marital privilege and we're talking about the spousal privilege. We understand the difference between those two. While they had discussed an amicable divorce, they kept putting it off because they were really fond of one day. They were really fond of another day. One day, approximately a year and a half ago, Bob left for work, but returned 30 minutes later and told Carol, I think I hit somebody on the drive to work. I didn't stop. This was going to ruin my life since I'm probably going to jail since I was speeding. I'm leaving. Don't try to find me, but go ahead and get the divorce and divorce me if you want. So Bob takes off. The police come looking for him, but Carol refuses to speak with them. A year later, Carol obtains a divorce from Bob, claiming abandonment. Several months ago, after Carol's divorce is finalized, police locate Bob. They got Bob. Now, he is now standing criminal trial for, well, he's now standing trial for criminal manslaughter. So, prosecutor subpoenas Carol to testify as to what Bob told her the day she left. So, as we know, we're not talking about spousal privilege because they got divorced. That privilege is ended. Spousal privilege is off the table. Even though it's a criminal trial, that's the trick. Spousal privilege is over. They've gotten divorced. But one privilege still survives, and that's the marital privilege. Things that are said within the marriage, within the confines of that marriage. Because, again, Bob said this while they were married. So, doesn't seem like she's going to be able to testify unless Bob waives it, because they both hold the privilege. If this was just spousal privilege, she could testify if she'd like. But here, because it happened within the confines of the marriage while they were actually married, marriage privilege survives the divorce. And unless Bob says it's okay, which he'd be crazy to do, then she's not going to be able to testify. So that's what we're looking for. And B says that clearly. May not testify unless Bob agrees to waive the privilege. Any questions on question number 13? No? I'm going to move on to question 14. 14 is, at trial, the prosecutor seeks to admit Patrick's statement that he stole money out of the cash register. If the defense objects, the court would. Well, that's not really enough, but we know seem like we have a statement that the prosecutor is seeking to admit. Is this statement, we're thinking about right now just hearsay, just plainly seems like it could be a hearsay issue because it's an out-of-court statement. They're trying to introduce it. But if Patrick is a defendant, we got party opponents. So there's a lot of things going on, but we don't really know. So let's see what the question says. Patrick was arrested and charged with felony robbery of a 7-Eleven during negotiations with the prosecutor. Patrick admitted stealing money out of the cash register, but denied threatening or intimidating the clerk, which is an element of robbery. Patrick explained that the clerk wasn't even in front of the store. He said, I walked in, I didn't see anyone, and saw the cash register open, grabbed the cash and ran. I never threatened anyone. Patrick's defense counsel, and the prosecutor try to reach a deal, but to no avail. The matter goes to trial, but prior to the trial, realizing that there was no evidence of intimidation or force, reduces the charge to misdemeanor theft. So now at trial, they want to introduce Patrick's statement that he stole the money out of the cash register. If the defense objects, the court should. Okay, so when did he make this statement that he just grabbed the money? Patrick, here it is. During negotiations with the prosecutor, Patrick admitted stealing money out of the cash register. But you could only use those statements if he pleaded guilty. Remember, that was the rule, and these are relevant to accept questions. I'm not sure if this is 410, but these are settlement negotiations, not settlement negotiations, plea negotiations. And one of the issues here was you had to plead guilty. He didn't plead guilty. He's going to trial. So these statements would not be admissible because the rules don't allow them in. So we're looking for the defendant's objection. We're looking for just exclude the statements because it happened during plea negotiations. And that's what D says. Exclude the statements. I think this is 410. Does everybody get that? Does anybody want me to go over that a little bit more? It seems pretty clear. All right, number 15. 15. All right, the plaintiff was right here. I'm going to go right to the core of the question one last time. The plaintiff objects to the evidence as an attempt to introduce impermissible character evidence to bolster the plaintiff's case. The court most likely. Okay, so we got character evidence and somebody's trying to introduce it. There are very limited exceptions to character evidence. Habit, routine is one. There's another one where if you're trying to admit it for another purpose other than character, things of that nature, or if this is a character witness and, reputation and opinion. So, very, very few exceptions, but let's look at this question. Plaintiff is driving home alone in a car when defendant, who was allegedly speeding, hits the side of the plaintiff's car while attempting to pass her. causing the accident. Plaintiff brings a personal injury claim against the defendant. Defendant counterclaims that the plaintiff was also at fault, and the plaintiff's failure to wear a seatbelt was a contributory cause of the plaintiff's injuries. The plaintiff proffers the testimony of the two witnesses, both who carpooled with the plaintiff for several years. Both witnesses will testify that they drove with the plaintiff at least 3 times a week and never saw the plaintiff without a seatbelt, and the plaintiff would not even start the car until everyone was buckled up. So this seems like as habit as possible. Every time this person drives, this person has a seatbelt, and these people are witnesses to say, yes, every time this person does this, every time this person drives, this person has a seatbelt. This person won't even start the car without a seatbelt. So, seems like habit. If it is habit, then it should be admissible, and that's what she says. Admit the testimony as evidence of the plaintiff's habit. So, C is the correct answer. So we've gone over the 15 multiple choice, and I will be back in about 45 minutes to go over the essay portion of the questions. So I hope you guys enjoyed this. This is your last chance to ask questions about these first 15 questions. So I'll leave it open to you guys. Do you guys have any questions about things that we've gone over today? Sorry about being a little choppier earlier. I had to get into my groove. Gail, Ron, and Sue, do you guys have any questions? You guys are all muted, just FYI.
No, thank you. That's great. Is it the same place for the next session?
Yeah. I'm going to send out another link, and then I'm going to go through the essay portion of it.
Thank you.
No problem. So I will see you guys in about 30 to 45 minutes. I'll send out the link, and you guys are welcome back. Talk to you guys soon.